And as COVID-19 has caused uh, to cause forced modernization even in India and across the globe. And so, if what was the actual need of ODR? So benefits of ODR, if you can just uh, shed some light upon this.
Sure. And so maybe the best way to start about it is to think about how did how did ODR come to be in the first place, and what did the world look like for ODR before we got to COVID-19? And the answer to that, obviously I can't speak to India in specific, but in the United States, for example, these sort of ODR-like procedures have been coming around for the past 2 decades. I mean, we've seen it at the end of the 90s and the early thousands with the rise of e-filing and e-discovery as means and ways to proceed with courtroom procedure. And that same thing has, of course, bled over into arbitration and mediation. And I think when we consider how it will be used currently in the midst of the pandemic, but also after, I think some of the main reasons why it was adopted in the first place are still applicable. And some of those things are the number of meetings that can be had, the time of travel, the cost of meeting in person. What do you do in the midst of a world event like a global pandemic? All of those were major reasons why ODR has continued to become more and more prolific and being used all over the world. And of course, just the speed at which things can be done. I mean, as the world continues to become more globalized, as businesses and organizations have more of a global reach, it's insufficient in a lot of cases to say, we have to wait for a team of people to travel across the world to have this meeting, make this presentation. Yes, can you hear me still? Sorry.
Yeah. I can hear you. Yeah.
Okay,
Okay.
I thought I might have
So
dropped off
I
for a
mean,
second.
no. We can hear you properly. So
But
I
yeah, but
mean
that was just
the
my last.
yeah.
Yeah, that was my last point, is just that, yeah, I mean, the practical realities for the need of something like ODR were one of the main reasons why it was
If,
gaining popularity before the pandemic. It continues to grow
hmm.
to this day.
And also, even I was referring to some few of the documents in which I found that there are few advantages of ODR as to economic viability, if I may talk about one. So you don't have to actually travel to go to the arbitration center, visit parties, physically visit parties, and all. Efficiency, speed, and flexibility are also few of it.
Absolutely. I mean, Vivek, I mean, I'll throw a quick question to you. I mean, if you could have the ability to have a meeting and to execute a contract over the course of a 24-hour period via ODR, instead of having to travel halfway across the world to do that, I mean, why would you not do that?
Exactly. And also one interesting point which I got to know uh, as the advantage, that it was something like the interaction. So even if you're in a meeting and you want to ponder upon a point or think about whenever so with respect to negotiation, when you're on the table negotiating on point, if you want some time to think upon it during physical interaction, you won't be able to do it that efficiently when you do it on virtually. Even if you are on the face on the video call, you can just get step back, reflect yourself and find your pros and cons, and then get back to this. Is one of the greatest advantage which I believe was for ODR. What's your thought on that?
No, I think that is a huge point. One of the most difficult things that we've seen in this pandemic and before were, sure, it's more convenient in some cases to have these types of meetings online, but in a tense negotiation, in a situation where there are high stakes, sometimes a little bit of the deal making process can be lost when you're only on the other side of the computer or on the phone with somebody. And that's just the reality that, okay, let's say you and I having an intense discussion or negotiation, and one of the breaks that you're talking about happens to happen well in person. We can go have a meal, or we can take a step away, and before we go back into the room, you might run into counsel and you might have a quick conversation that might change the entire dynamic of the negotiations. Well, now there's no chance to do that. You're just turning on the computer or turning it off. And I certainly have seen that on at least a couple of occasions. I think that kind of adds an extra barrier, so to speak, between the two sides, and makes it difficult
Exactly.
sometimes to resolution.
Exactly. I mean, so if I move forward, what so how about, so in physical interaction, the emotional part also plays the role. And in ADR specifically, if I talk about mediation, mediation is not about law. Mediation is somewhat emotion plays a big role in mediation. So how to tackle that difficulty? I mean, it's a drawback for ODR, I believe.
Well, Vivek, don't tell anybody that mediation is not based on law. I might be out of a job. Um, um,
Okay.
it looks, but I think I did just see a message that maybe the audible is not coming through for somebody. But maybe that can
Okay.
be addressed.
Well,
But I would reframe it this way, Vivek. I think first mediation. I think mediation is definitely based on law. I mean, certainly in a mediation, you tend to see people get a little more emotional than they would in an arbitration. I think by the
hmm,
time something gets to arbitration, or by the time something you get to courtroom litigation, the sides are a little bit more calm. The lawyers have told them what to expect. They've, have said to them, this is how to control your emotions. I think in a mediation, oftentimes you don't know what you're going to get. I've had a mediation where the other side sends their CEO and their business team, they come in very emotional, and they don't really, you've kind of alluded to in that case. For sure, they didn't want to talk about law. They said they didn't want to hear any, quote, legal mumbo jumbo. They wanted to talk about their
hmm,
feelings and what their feelings of the facts were. Um, so I think that is, I do appreciate the point that you're making there. But I think as it goes to mediation in particular, yeah, I would think that this sort of electronic platform continues to be able to add a little bit of
okay.
a buffer from a heated conversation when you're face to face with someone across the table.
Okay. Do we have, okay, moving further, do we have any statutory definition or legislation on ODR across the globe?
So there is no uniform, there's no uniform statute across the globe. And something I think we'll talk about a little bit later. UNCENTRAL has provided some guidance. Various jurisdictions have specific statutory regimes. But one thing that you're seeing, even in the countries like the United States or the UK, for example, that do have statutes that address ODR in a specific way, there is a little bit of we'll call it just a gap between, I think, the understanding of the lawmakers and the technology. So that is to say, when you don't have a really deep understanding or appreciation for the law that you're writing and how it connects to the technology that exists, there's sometimes these little discrepancies in the laws that exist. So I think that is something for world governments and organizations going forward, that you really need to make sure that they're having people that understand ODR and the technology behind it, helping to draft laws. Otherwise, you end up with legal provisions that don't make the most sense. One example that I'll
Okay.
give of that I think is really funny, or not funny, but just it makes you ask questions, is a lot of statutes in U.S. law, and I think in especially civil law jurisdictions, make reference to certain things must be done in person or live. Well, what does that mean? Is, if
Hmm,
I'm requiring that a witness witness something live, does that mean that that person has to be in the same room with me? Can I have a video feed
hmm,
where I hold up a piece of paper and I sign it in front of them? All those types of things are questions that are practical and real. I mean, I think for millennials or people that are used to growing up with technology or using technology, we would say, sure. I mean, that's the same thing. But for a more seasoned practitioner or a civil law jurisdiction, that's an ambiguous question. It's an answer it's an answer that we need.
hmm. Yeah. And also, with respect to the same thing, I mean, carrying forward, any statutory definition, I mean, I was going through one UNIS ancestral document. There's a technical guide which they have released on ODR. So, I mean, it's just a technical guideline. In the preamble itself, they have mentioned that it's not a strict it doesn't have a strict binding effect. It's just a guideline thing. So do you want me to, I mean, do you want me to read the definition exact? I mean, it's not something different like ADR. It just says it's a blend of law, as you already mentioned. It's just a blend of law and technology. And ADR taken on a virtual platform. That's it. There's nothing beyond that. With that being said, I mean, have you ever? I mean, I would like to ask you how these online mediation, online negotiation, and online arbitrations are conducted. Although the procedure would be same, like it is conducted in physical format, but there would be some technicality and differences in online mediation or yeah.
Yeah. So yes. So I'll draw comparisons in my answer. So typically, what would happen in a mediation or an arbitration is first thing that happens is both sides come together and there's been an issue that's been identified. One side will say to the other, "Hey, we need to address this issue." They'll negotiate back and forth. If it's still not settled, then there will be a dispute resolution mechanism that the parties agree to go to. In either case, the party seeking damages or seeking remedy will submit either a request for arbitration or a request for mediation. Typically, in that document, they will identify the forum, how the procedure should go, based on the terms of the arbitration clause or mediation dispute resolution mechanism. So that is what we're all used to. That's all of that is exactly the same as it would work in ODR. Now, the next thing that might be a little bit different is if it's an institutional mediation or arbitration, is that the organization then has to make the decision. It usually asks the parties, have they consented to conduct this online? You know, if they haven't, then I suppose the forum can make a decision on their behalf. But typically, especially in these times, what we've seen is that both sides understand that it's just not practical to try and meet in person. And so the next phase of deciding who the mediator or the arbitrator will be can still operate as it normally would. Now, the next thing that happens is something that, and I'll discuss this a little bit more in our discussion, is there are typically two ways that this can then proceed. This can proceed from the neutral being in the same place as one of the parties, and the mediation or the arbitration going forward that way, with one party being in the room as the mediator and arbitrator, and the other party basically video linking in or having a live or continuous video loop. That can sometimes be difficult because there is a little bit of a perception that, you know, well, the neutral is hanging out more with one party than the other. Even if there is no wrongdoing, it just doesn't look good. But I mean, I've seen that in practice myself. The other option is kind of what we're doing here today, where we've got, you know, 70 people in different spots, presumably all around the world, and everyone is video linked in. And so then you've got a claimant in one place, a respondent in one place, and a neutral in one place, and they all sort of discuss in turn. Some of the video conferencing platforms have the means and the ability to basically, and I think the vSmoot used this to great effect, you have basically a central room where all parties join together, and then the claimant and the respondent each have their own rooms where they can talk, and then the neutral, whether they be the mediator or the arbitrators, can go to the individual rooms back and forth or move the parties as they need to, and the same can be done for witnesses for discussion. But again, and one more point that I would make before finishing that comment is that the conversation that you would have, you know, if you were sitting in the live arbitration and things are getting heated and you need to mention something to your co-counsel, where usually you could just lean over and mention something to them. Well, now you've got to type it to them. And, you know, and at least for US style discovery or arbitrations that have US style discovery attached, well, if you do that, well, now you've created a written record, and that's discoverable. And that creates other issues, especially if this matter ends up in a courtroom at some point.
Okay. Yeah. Well, I mean, yeah, through your comment, I believe, in the ODR, whenever you happen to be a part of any ADR or ODR, so there would be three parties already: one the claimant, respondent, there would be one neutral, and in a physical ADR, there will be only three parties. But when you come on online and in the ODR, technology also becomes the part of your system, and it acts as a common platform for all three. How technology is used there, I mean, for notices, for communication, for a caucus, how caucus is taken, I mean, in mediation, how is taken on ODR? If you can shed light upon that.
No, that's a great point. It's a great question. So certainly, your idea and your hope as counsel or a user of any of these ODR platforms would be that the technology is either integrated with the neutral or the third party, but at minimum, it must be transparent and it must be reliable in order to gain the trust of either any of the other parties, the neutral themselves or the claimant or the respondent. One arbitral organization that has done a pretty proactive job of making sure that their process is transparent is an organization called Delos. That I actually interviewed in episode 1 of season 2 of this show. That is a arbitral institution that is up and coming and has really been one of the leading organizations in talking about ODR and using ODR or making ODR options available to parties that are now sort of stuck and sheltering in place. But absolutely, you make a great point that the technology could benefit one side or the other. So there really has to be a lot of effort made to make sure that it is fair for all sides. And when we talk about benefits, say you're using a company to provide this video conferencing or this information sharing that is based in a jurisdiction that doesn't comply with your confidentiality rules, or it doesn't have the bandwidth to provide connectivity or security to one side or the other, or provides one of those things in a better capacity to the other side. That is certainly not balanced and puts one party at a disadvantage. Beyond that point, something as simple as, and I think this is a huge issue, is data privacy and security. Oftentimes, especially for technology companies, you're talking about highly sensitive intellectual property. So, to have something that could be Zoom bombed, for example, is just wholly unacceptable. I mean, that's a nightmare situation that you're talking about potentially millions, if not billions of dollars in potential losses if that information is leaked. So, the ability to secure your data, to keep it encrypted and to prevent third parties from being able to hack the proceedings, that is a very real risk. If the proceedings are being recorded, securing that data, all sorts of those things are very real situations that counsel and users both have to make sure that they are being mindful of as they go into these proceedings.
Okay. I mean, yes. So if if a very particular question, so how claimant, if suppose I want to initiate a mediation proceeding,
Sure.
so for that, how would I use an ODR platform to send him a note? So to send the other party a notice, how sending notice part works?
So typically what you would probably do is not so much confer with the ODR platform itself. Well, so first question, if you have a dispute resolution clause, does that dispute resolution clause mention any specific institution? If it does, then in your request for mediation or arbitration, you'd make a recommendation that that platform is used. That's probably the simplest thing to do. If there's not, and it's ad hoc, then you would need to work with the other side to agree on an ODR platform. Absent those two things, then yes, as you just suggested, you would just reach out to the ODR platform directly and say, this is what we're intending to do, and to see if that platform is capable of assisting in that matter. That's kind of the worst case scenario, but typically, if it's a situation where the parties know that they're not able to meet in person, you can usually make a recommendation or come to an agreement on a place where is neutral and acceptable to both sides.
Okay. I mean, yeah, and okay. So if I also ask, now ODR has become, I mean, is coming more into limelight these days. I would also would like to know, to trace the history of ODR from which organization was the first organization which started upon thinking upon this, or when these things all started. Any idea about that?
Which was the first organization to do ODR?
To do ODR, yes.
Oh man, I mean, I don't don't put me on the spot like that. I'm not sure which one the first one is. I don't want to get that. I don't want to get that one wrong.
Who are the better players? Okay, so I mean, if I tell you about India scenario of India, the government has not formed any legislation on it. And
Hmm.
not even the technical guides like unicitral or a lot of papers. We only have a lot of papers now, but Indian government has not formed a legislation, but they want to promote. The only document which I had got, which I had already shared with the the attendees, to the attendees, where the government has listed down several startup entities who are venturing into ODR field,
Hmm.
but have not dwelled upon it. Haven't framed any guidelines yet. So what is if I can see so many startups and organizations working on ODR in India, what is the current scenario of ODR across the globe or in your country?
So, so, so I think it's similar. I think that it's like with a lot of industries right now, there it's like it's gone from a slow sort of simmering phase or being in this quote startup phase to now there's a huge demand for it, and everyone is trying to distinguish themselves as the best platform to do so. Um, I don't think that there is a definitive champion yet, or the gold standard yet. I think there's a lot of different organizations vying for that title, but I think the eventual winner and market leader will be whoever is able to, again, have a reliable service that the users and counsel can reliably understand. And I think really, and I hate to beat the drum on this, but has the most level of data privacy and security. That is an issue that, if you can't provide those things, really parties and users are just not going to utilize your platform. And I think that's probably the single biggest thing. And from there, you want to talk about, your capacity and all these other things to be able to do. But unless you can address that issue outside from the outset, I think it's a difficult obstacle to overcome.
How about one more difficulty of ODR? I believe would be the lack of trust, as privacy would be one of the things adding to it. How about what the organizations may do to bridge this gap, lack of trust?
Well, I mean, I think to some extent, I think it's a situation where the market will kind of bear that out. So, I think all of the major arbitral institutions at this point, excuse me, have gotten to a point where they're able to do some level of ODR, and have gotten the ability to do some level of ODR, and they're continuing to investigate how that can be best utilized. I know the ICSID, for example, in Washington, D.C. from the World Bank, they were already doing a lot of ODR proceedings before the pandemic. And so they've continued to just kind of continue to grow that. And I think that they provide a pretty good model for how those things can continue. From the UNCITRAL rules that we were discussing earlier, the ability to resolve some of these more difficult disputes, cross-border disputes, disputes where people cannot meet in person, or there's a certain amount of danger, are the types of things that are really attractive for the uses of ODR.
Okay. Hmm. Okay. So I mean, if so also and also few organizations. So okay. So let me ask you this: how about ODR being how ODR is? I have seen several organizations, for example, the food delivery applications, or they also have set up their dispute resolution system on their own, where they take the petty claims from the consumers and they settle it out. How this platform is different from the how what they are doing, what ODR would add upon uh, this system. I hope I'm clear.
So I
I
think
mean,
it's not so. Sorry.
these organizations have also been using and such kind of ideas to resolve disputes between the consumers and between the consumers and them. So how ODR and the intermediaries, how these platforms which are coming up now would help in us help help them to resolve such disputes.
Yeah, so that's a really interesting question, Vivek, and it's something that I wouldn't say that they add on or take away from each other as much as they operate in parallel. I think they're just kind of two different systems. Um, I won't disclose which bank. I don't want to give them any free press or have them coming after me for libel. But a bank that that I have some experience with, they use a sort of ODR program, and they have like an online arbitrator as well, where basically, if there's a dispute with this bank, then the customer provides, whatever evidence they have, and the merchant or the person that they're disputing with, or even the bank itself, provides its counter evidence. And then appears to me, it doesn't appear to be a live person as much as it does some sort of AI-based or online arbitrator, or AI-based, arbitrator, which is really fascinating, because more or less what that system or that program would have to do is have a preset set of type of rules and see which one best satisfies those conditions, and then come to a conclusion based on that, which, by the way, I think is the direction in which ODR will eventually reach. Not just ODR, but I think commercial dispute resolution will eventually reach.
And how these thanks for bringing this point, and my next question will be on this only. How these neutrals are appointed? I mean, is there some different mechanism?
Yeah, I think that is a I think that is a very real problem, because even in a system like that defines its rulemaking in an objective sense, it's only as objective as the programmer or the rule writer themselves. So if the rule that it is deciding based upon, or the inputs itself are based upon, are biased in favor of one side or one type of claimant or respondent or the other, then for sure that's going to be a tipped scale, so to speak. So that's something that we talk about who's going to be the champion in this market, especially in the AR neutral market. Whoever can decide or develop the most neutral and program that is deciding the most consistent and predictable sorts of outcomes, that will be the market leader. And by the way, it's not a question of if, it's a matter of when. I think that's definitely going to happen at some point.
The appointment has been made more neutral and more transparent. That would make them succeed also in this market.
Sure, absolutely.
And how about sharing your experiences of being a part of any online mediation or arbitration? Any difficulties? So you can share your experience with that. We can gauge what difficulties arise and what advantages we have.
Yeah, so I'll share a really easy one. I have a bunch of mediations that are ongoing, and most of them will be ODR related for the foreseeable future, at least until the world opens back up. But just last month, we had an ODR, and this one I really get a kick out of telling, because it was originally supposed to be a live and in-person mediation, and because of COVID-19, some of the people that we had could not attend, or the opposing side's counsel was not comfortable having those people in their office, nor did they want them to be exposed. So it was, we're talking about over the course of 48 hours, proceeding that was supposed to be wholly in person with the mediator in London, and we've already traveled and everything, becomes overnight an ODR. And so we had to scramble, and we had to get set up get prepared for this different style of mediation, to make sure that we had the technology ready. But we didn't use a separate ODR platform. The institution we used was the ICC in that case, and the ICC, basically deferred to us and what we were able to do. So what we did was we had a continuous video link for about, 10 hours or so, and we were in one place. There was the video link connecting us to the mediator, and then the mediator was at the offices of opposing counsel. And so what would happen when we had the caucus, for example, would be that the mediator would stay in our room and talk with us, and then go talk to the other side as necessary. And then when we all needed to talk, we'd all be in the same room. But that was kind of a unique experience. That was interesting to do it that way, to just have one continuous video link. And so, like, when we wanted to have lunch, for example, we would all leave the room and just kind of turn off the lights and then come back, but the video would still be running the entire time. So that was interesting.
Okay. Okay. And so if I move ahead, I had a very interesting question personally in my mind. I have heard that let me put it directly, will the human neutrals will be substituted by AIs? I've been reading about this a lot. It's a lot on papers. What is your suggestion on it? Where the neutrals appointed, as we are also moving ahead and we have got to a level that online arbitration mediation have been conducted. I think this is also not far that AI would substitute human neutrals.
Yes. So I'm going to make a bold prediction. I think that the answer to that question, as I said just a moment ago, is absolutely yes. I think that AI neutrals will eventually begin to replace humans in the not too distant future. I think there will always be some demand. I don't know how big it will be for human neutrals, for those that just insist upon it and are willing to pay for the human time and effort. But I think I would not be surprised if within the next 15 to 20 years, we see a massive shift towards AI neutrals. You heard it here first.
Yeah. And yeah, and okay, if I take you again back to the stages of proceedings and how the proceedings are conducted, I
Sure.
believe there would be not much difference in making submissions by the claimant or taking evidences. It's just that the technology plays its part.
I'm sorry, you cut out
Yeah.
there for just a second, Vivek. Can you say that last part again?
Yeah, I'm saying if I take you, I mean, I'm taking I'm just clarifying it. Uh, Apart from the involvement of technology, how the submissions made by claimant or the respondent and the neutrals coming into picture, apart from the technology part coming into in, there is not much difference with in between ADR and ODR. Is
No,
that
that's
so?
true. I know. I think that that's true. One of the guests, and again to point to my show, but to also more importantly point to someone that is has been writing on this topic for years, is Professor Benjamin Davis out of Toledo, and I actually just interviewed him recently for the show. But one of his quotes, or one of the things that he said, was that ODR is kind of like water, and it always finds its level. And I think that that's true. I think that, again, for ODR and ADR proceedings, the standards for evidence are the same. They still have to be met and have to be accommodated for. So the standard is still here. ODR kind of helps it fit into that substance or fit into that form so that it can continue to meet the needs of both parties. But essentially, the submissions are relatively the same. Now, one difference that there might be, and I point this out specifically, is that say that you might have used in a live mediation or arbitration one type of evidence because it's the most effective and most impactful if you're going to be having a hearing. But if you only are able to rely on ODR submissions, then because of the limitations of only being online, you might have to change that format, or you might have to change how it's structured or laid out.
Okay. And this also leads to one of the benefit of ODR also, transcription of the proceeding also happens. You would not have to worry about missing any argument or evidences. Transcription is also one of the benefit of ODR. I mean, am I right?
Yes, sure. I mean, transcription is definitely an important thing. I mean, so oftentimes a lot of these hearings may be recorded, like this conversation here, but recording is not necessarily perfect for capturing everything, and typically, if you're in court or sometimes in a mediation or a deposition or an arbitration, you would have someone keeping a transcript of what's being said. But in this case, I mean, I don't know about you, Vivek, but I don't think anyone in this meeting is keeping track of every word that's being said.
I mean, if I let you know, the meeting is being recorded.
Yeah, of course.
Okay. So okay, any light upon what is your view how ODR would change post COVID-19? What changes, what ups and downs would come, what difficulties which we may face, and we can definitely, I mean, develop in ODR. What will happen the scenario of ODR in post COVID-19?
So I think that to put the bookend on what we were discussing about 5 to 10 minutes ago, I think that the difference will be that you're going to eventually, through the market competing with itself, you will eventually have a handful of firms, probably one on each continent or a handful from each continent, or maybe it'll even be country specific, that will emerge as the most reliable platforms for ODR proceedings. And I think that that they will be continue to have the industry best standards, best practices, and the ability for users to continue to one, rely on their services, to be able to issue awards, and the preferred choice for mediators and arbitrators.
Yeah, I mean, that was I mean, I have done with all the questions. I would like to make it more interactive by taking questions as well.
Sure.
So we'll just visit the chats and ask all the attendees to post all the type of questions which you want to get clarified, because I don't think so. Chris would be really happy, and he has the experience of perspective, or having perspective ODR. I mean, worldwide perspective. So you can ask all the questions which comes to your mind.
Sure, please do. I saw a few questions come through, so happy to address those.
So there's Harish from Advocate Harish. Orders passed by ODR is binding, and how is it executed? Very good.
Sorry.
Yeah.
Let's see. Orders passed by ODR are binding, and how are they executed? Okay, no, so that's a good question. So it depends. The first thing is if it's done by, so this might be something that's unique to the United States. In fact, I'm pretty sure it is. So in the case where it's basically the so-called compulsory or mandatory arbitration is enforced, basically the consumer or the company holds a lot of power in that situation. So it has the ability to say that, the ruling of the arbitrator is final and binding, you're waiving your rights to pursue certain claims in court or appeal. And so if we look back to the example I was giving before with the bank that has its own, kind of internal arbitrator or uses this one platform to make the decision, then in that case, you would be stuck with the final order from that AI neutral, which is not great. And I don't think it's very satisfying, and I think has some concerns of being legally challenged. But more likely the case is that if you're in a standard mediation or arbitration, again, the parties have made their submissions. Presumably there's not been a challenge to the jurisdiction or the authority of the arbitrators or the mediators. And so when it gets to the stage where an award is rendered, that award, assuming it's in a compliance with the New York Convention, should be equally applicable, or the Singapore Convention for mediations, should be equally applicable in any jurisdiction that's New York Convention party member.
I hope that answers Harish's questions.
Right. One more point to mention that's a point of distinction. So what you would want to think about is, so one of the questions that we talked about earlier in this discussion is two things. One, or not necessarily two things, but just thinking about these principles. So when we talk about what does live and in person mean, did all the aspects of the proceedings or the submissions and even the arbitrator or the mediators signing an issuance of the award, do they comply with the statutory laws? So that is to say, some arbitral rules require that the arbitrator must issue the award from the seat of the arbitration. Well, if they do that from their home in Botswana when they should have been in Zurich to issue the award, well, does that comply with the terms of the applicable statutory law? And if it doesn't, does that mean that award is enforceable? These are valid questions, and there's not a clear answer.
Yeah. Okay. I mean, that is so it's a difficulty which needs to be addressed. And there's one more question which I got through my private message. How secure are the proceedings, and what how secure are the proceedings? Is a very good question.
So obviously that would vary and depend upon which platform you're talking about. I'm sure some will have higher standards than others. As I mentioned before, Delos is quite good. They have they've gone through great efforts to kind of really establish their brand as a reliable source and a secure source. But yeah, every arbitral institution and third party is going to have varying level of encryption and security for the proceedings. So you would really just need to kind of, the question I would ask is, if you're going to use an ODR platform, or you're going to let the institution decide one for you, I would ask about what the specific technological things they're doing to secure the proceedings are. And if you've got an IT person on your team, I'd run that answer by them to make sure that it's sufficient.
Okay. I've got one question from Govind Singh. AI neutrals, weren't they be subjective to rules of programmer? How it will make trade-offs acceptable? Will it screw the outcome on past precedent as per the success rate of past mediation?
Yeah, so I think that this question kind of goes to something we mentioned a little bit ago, and that is, yes, absolutely. The programming of the AI neutral is certainly subjected to the same biases and thinking and thought processes of the person that programmed it. So the only way to combat that is to try and program something that's as neutral as possible, and then to continue to upgrade it and edit it based on the biases that you receive. But that's absolutely true, and that's a weakness of that sort of system. But I would also point out that that's also a weakness of humans as well. I mean, I think we all have our own biases and presuppositions that exist, and so the idea with the AI neutral would be that you at least have some sort of standardized bias instead of humans, which might change from one moment to the next.
Yeah. So there's one question from Martin as well, which says, do you think that the award would be challenged based on the unsuccessful party being unable to present their case due to the disparity of the party's internet connection?
I mean, so yes and no.
Yeah.
If they raised the issue before the award was written, for sure they might have a valid argument there. But I think because typically what neutrals will do prior to closing the proceedings or closing the hearings is ask if the parties are satisfied with their ability to convey their case, and ask them to confirm that, usually in writing. And if they do that, then it kind of weakens the argument later that they felt like there was a disparity in their ability to communicate via the internet connection. Now, I guess if it's so plainly obvious that was a problem, I guess that could be an issue. But if they have not raised that at the time and they didn't raise it until after they lost, I don't know how willing the arbitrators are.
That was actually very interesting question to point out. And from Utkarsh Tripathi, I have a question which says, talk about AI on point of personal meeting. Does VR and AR to be playing the role in the future? Many universities has developed such mechanism, for example, MIT, IIT separately, for augmented reality meetings.
I mean, I'm a big Star Trek nerd and I like sci-fi and, maybe even a little Black Mirror, but I mean, I think that, that's not so crazy to think of. I think the technology is not there yet. One of my alma maters, Tsinghua, which is a Tsinghua University in Beijing, is a pretty big competitor with MIT. And I imagine a lot of universities are trying to develop that sort of technology to be able to have these sort of virtual reality meetings. And I think that'd be really cool. I just think that they haven't found something that doesn't weigh 15 pounds that you have to put on your head and doesn't glitch out. But I think that, at some point the technology will be there. And I think that's probably what will happen.
From Nikhil Saini, we have a question. If any of the party is not satisfied with the ODR award, then what are the alternative remedies for the party to get the award?
The same remedies that they would have in a regular ADR proceeding. So if it was an arbitration, then probably not much, unless there was some sort of basis for challenge that you would otherwise have. In a mediation, mediations are typically not binding. So consolation, for example, that might be a little bit different. But the same remedies that you would have otherwise. If it was against litigation in court, you would have the same levels of appeals that you would have otherwise under the rules of civil procedure for the applicable jurisdiction.
Yeah, in mediation, it would depend upon what consent, on what agreement, on what they are agreeing, on what agreement.
Yeah, that's right. Now, if sorry for cutting you off there, Vivek, but of course, if they come to an agreement and they sign an agreement in mediation, then pursuant to the Singapore Convention, which came into effect last August, for I think like 50 member states, that of course would be binding.
I have the answers on Nikhil's question. I'll move forward. Mr. Utkarsh has asked it already in preliminary stage, and maybe in future we will be able to have greetings from different part of war, feeling like we are in the same room courtesy of augmented reality.
Yeah, I think that might be more of a that might be more of a comment than a question, but yeah, it is.
Yeah, that's not.
But you know,
So yeah.
I agree. Yeah, it does kind of feel like we're all in the same room. I wish I could be there to greet everybody, and I haven't made it to India yet, so I need to make it there sometime in the future.
There's question from Varsha: how ODR will be more useful when it comes to commercial disputes?
I mean, so one example is the one that I gave just a moment ago, but you know, one very specific example that I'll give, and I won't tell exactly what regions we're talking about, or you know, disclose too much specific information. But what I will say is that imagine situations or instances where you've got a company that does business in one part of the world, but maybe due to military conflict or to some other restriction, like a lockdown or something similar, they're not able to go into that area. Well, you know, that's obviously going to affect the supply chain, and that's going to affect various contracts in one way or another. So, especially for large multinational companies, absolutely there will be a need, oftentimes, to talk and to work with people that are in those areas, counsel that might be in those areas, and ODR helps kind of bridge that gap when the reality of meeting in person just can't happen.
From Sindhu, we have question: legal personality has not been conclusively given to AI yet. So what that disqualify them from being AI neutrals? If not, how would one go about challenging it?
That is a complex question, and I have no you know, pride lost with not having all the answers to it. Yeah, I think that it would that is a very country and jurisdiction specific answer. You know, so for the United States, for example, or let me not answer it that way. What I would say more is it depends on what the parties have agreed to. If the parties have agreed that AI programs or things can be used in order to make these types of decisions, then of course it's fine. But you know, to unilaterally do that without the consent of both parties, because as we always remember, and as I started my comments today with, ADR is a creature of consent, and that includes ODR. So if the parties haven't consented to using such a non-person to resolve the dispute, then of course it would not be grounds to use it. I wouldn't use it, and that would immediately have a grounds to challenge it. And you'd win, I think, in just about every jurisdiction. But if the parties have already agreed to it, and now one party is dissatisfied with the result and tries to challenge it, that might not work. But it's definitely a question that bears further examination as AI becomes more prolific. Right now, AI needs a lot of handholding from human people to be able to do things. But you know, at the point when AI becomes more standalone, in the Skynet future, in the Terminator future, that is certainly something that we'll have to consider. You know, maybe the answer is that there's a person that acts on behalf of the AI, which is kind of life imitating art a little bit, but maybe that person is the legal personality that issues the award.
There's a question from Devisha as well. Does ODR affect the jurisdiction of a matter in any way? If yes, how?
Does the ODR affect the
jurisdiction of any matter?
Not really, because the only reason you would be in an ODR, presumably, would be once jurisdiction has been stipulated or agreed to.
The cross-border. I mean, there's one question which I want to ask: how beneficial it would be? ODR would be definitely a boon to cross-border disputes, if I'm not wrong.
Would definitely be a what to cross-border disputes?
It would be very helpful in resolving cross-border disputes.
Well, sure. I mean, for a number of reasons. I mean, again, you know, the issues that we talk about in terms of just factually being in the same place, or being able to go to some places that you may not be able to go otherwise. Yes, I mean, I think, you know, again, you know, I kind of want to demystify, and, you know, if you walk away from this conversation, I want you to understand that ODR is just a means of facilitating the proceedings that are already going on. So it's not like it's this wholly separate thing. It's like a component of the ADR structure that already exists.
Okay. Yeah. That moving ahead, Nikhil has asked again, does ODR play an important role in the property circumstances? In the property circumstances. I mean, related to property cases?
I mean, it could. I'm not really exactly sure what they were trying to get at, but it could, yeah.
Okay.
Yeah,
From
if you
Ajay, we have a
want to type in
question. Yeah.
quickly what exactly you meant, that would might be helpful.
Yeah.
But
Yes, Nikhil. So there's question from Ajay. How does ODR address the lack of legal knowledge parties have in case they are from different countries that have different laws for the same matter?
so in the same way that any ADR proceeding would, so if you've got a party from India, for example, and a party from Mexico, for example, those are two different legal systems, and so the idea would be that you would need to hire a counsel or have representatives that understand the applicable law of the dispute and are able to represent the interest of their party in trying to resolve that conflict.
And also one more thing, how neutrals are. So, for example, the mediator is there any specific training which needs to be imparted to mediators or the neutrals who are going to be part of ODR?
Yeah, I would say so. I think I know, well, let me not say I know. I am aware that I think that the IMI, the International Mediation Institute, is offering trainings right now for people that want to be mediators using ODR. I know that there are other organizations that offer similar sorts of training for folks that are going to be doing that. And I think I would be confident to say that any platform that is being used as an ODR platform probably has some sort of training that you can do with them. And at some point, I would imagine there's a lot of overlap. So once you do a couple of them, I'm sure that they're probably pretty similar.
Okay. So I hope that answers. I got a private question related to this as this only. Miss Gayatri has asked me the question. The last question, I believe, by Richa Fulwani. He's asking, considering the big threat to data privacy in case of ODR, will it be smart to reply upon ODR post the pandemic?
I think so.
Smart to rely upon.
Well, right, to rely
I think
upon. I think that.
To rely upon, yeah.
Yeah. I assumed. Yeah, I mean, so I mentioned data privacy. So the reality is that anything that is on the internet can be hacked. I mean, that's true. I think that there at some point, there has to be a sort of balancing of the risks there. And I think that, yeah, I mean, I think that there are parties that for sure will have these sort of confidential conversations, because you can also consider that there are times when business people or lawyers are talking about highly confidential information over the phone even, or in their offices. And there's always a possibility that someone could spy on you or hack your phone line or something like that. But it's just something that, as it goes to ODR proceedings, should be thought of in a very, attentive and proactive way, that it's not something you want to leave sort of in the background. Because when that happens, you have, again, something like Zoom, where random people can just join your proceedings. You want to make sure that you have done your due diligence and that the organization has done its due diligence to protect against that sort of thing.
Yeah, I think let me just check. Do we have any question? Yeah, I think that's it. We can end the session, right? Thank you so much, Chris, for joining us on this platform and sharing your insight and sharing us about ODR and your experiences in ODR. We would love to host you on our platform again. With that, thank you so much. Thanks to Tales of Tribunal. I would also recommend please join Tales of Tribunal. It's a very good initiative by Chris. Any words, last word from Chris? Final word.
Well, thank you all again for having me on the show. Feel free to follow Tales of the Tribunal on LinkedIn. We would love to have you. Tune into the show. If I can be helpful, well, I don't know. Yeah, reach out to me on LinkedIn. I'm very easy to find there. I'm happy to talk with you anytime. Thank you all for your questions, and keep working hard. And I look forward to seeing you as colleagues soon enough. So thanks again.
Thank you so much, Chris. Thank you.
All right. Take care now. Bye.
Bye.